Hello and welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. In today's video, we'll discuss a highly significant constitutional issue, the reference of 14 questions by the Honorable President of India to the Supreme Court under Article 143(1). These questions relate to the Supreme Court's recent judgment imposing time-bound obligations on governors and the President in giving assent to state bills. The question we'll explore is, will the Supreme Court answer all these 14 questions? And is it constitutionally bound to do so? Let's understand this in depth. Part 1. What is Article 143? Article 143(1) of the Constitution of India gives the President power to seek the advisory opinion of the Supreme Court on any question of law or fact which is of public importance. Here is the actual constitutional text. If at any time it appears to the President that a question of law or fact has arisen, or is likely to arise, which is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and the court may report to the President its opinion thereon. But pay attention to the phrase, the court may. This means that the Supreme Court is not bound to reply. It has complete discretion. The reference is advisory in nature, not mandatory or binding. Even if it gives an opinion, the government is not constitutionally obligated to follow it. Part 2. Has the SC refused to reply in the past? Yes. The Supreme Court has exercised its discretion under Article 143(1) several times. Some key examples. 1. Kerala Education Bill, 1958, AIR 1959 SC 956. The President sought opinion on the constitutionality of a proposed state law. SC gave a partial reply and refused to comment on hypothetical provisions not yet in force. 2. Kaveri Water Disputes Reference, 1992. The President wanted clarity on the role of the tribunal. SC refused to answer, saying the issue was not suitable for an advisory opinion due to complex facts and political nature. 3. Ram Janmabhoomi Reference, 1993. The question was whether a temple existed at the disputed site. SC declined to respond, noting it involved historical facts and politically sensitive issues, not a legal question. These precedents clearly show that the Supreme Court can legally and constitutionally refuse to answer a presidential reference. Part 3. The current 14 questions sent by the President. In April 2025, the Supreme Court delivered a historic judgment mandating that governors and the President must act on bills within a reasonable time, and inaction could amount to deemed assent, using Article 142 powers. In response, the President of India sent 14 questions to the Supreme Court under Article 143(1). These reportedly ask whether the SC can impose deadlines on constitutional authorities, whether deemed assent is constitutionally valid, whether the judgment violates the separation of powers. These questions indirectly challenge the very ruling passed just weeks earlier. Part 4. Is there a political angle? Many legal experts and opposition leaders suggest that the timing and framing of these questions indicate a political motive. Here's why. Opposition-ruled states have accused governors of deliberately delaying assent to bills. The SC ruling curbed that power, bringing accountability. Now, the Union government appears to be countering that judgment through this reference. This raises doubts. Is the Article 143 reference being used to bypass or dilute a binding SC judgment? Part 5. Will the Supreme Court reply to all 14 questions? The likely answer is no. Why? Article 143(1) is not binding. The SC may choose to answer some, none, or all of the questions. Questions that require the SC to review its own recent judgment are inadmissible under advisory jurisdiction. Vague or politically sensitive queries may be refused. The SC has a constitutional duty to maintain separation of powers and not entertain political or hypothetical matters. Hence, based on constitutional text, judicial precedent, and legal principles, it is almost certain that the SC will not answer all 14 questions. Conclusion. To summarize, the President can refer questions under Article 143(1), but the Supreme Court is not bound to respond. The Court's opinion is advisory, not binding. Given the political context and past precedents, the SC may selectively answer or refuse altogether. This matter will have deep implications for center-state relations, judicial independence, and governor accountability. Let us wait and watch how the Supreme Court responds in the coming days. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.